Everybody be seated, please. May I proceed, Mr. Prince?
Thank you, Your Honor. Dr. McElfresh, I just wanted to touch on one kind of introductory point. You indicated you're being paid for your time, correct?
That's correct.
And you indicated that you weren't exactly sure as to how many hours you had, but you said probably 8 to 10 or so?
I think so, but that was probably analytical time. I don't have a record in front of me. There's been some trial testimony and
well, let me ask you this.
My travel here.
Yes, sir. That's what I was going to get to. Let's say since November of 2018, you've had to travel back and forth to Tallahassee for this case several times, correct?
2, I think.
Okay. So you, of course, get paid for your time as it relates to those instances, right?
Yes, and I actually don't think I've billed for that, but I would get paid for it, yes.
And have offered testimony on a couple of occasions. Of course, that's time you get paid for as well, right?
That's correct.
And so what's your best estimate as to how many hours you've worked on this case roughly since, say, November of 2018?
In terms of analytical time, probably 8, 10. There's probably another 10 or 12 in travel and courtroom.
So roughly 20 or so.
Okay.
I mean, that's what you're saying, right?
Yes.
Okay.
Again, I'm sorry, I don't have that information in front of me.
And I'm not going to hold you to exact number. I just want to clarify that's during the time period we're talking about, roughly November of 18 through today, 10 to 12 hours in travel time, 8 to 10 hours in terms of actual analytical work.
Yes.
Okay. Do you recall being deposed back in November of 2018?
Yes, that was about the right time frame.
Do you recall being asked during that deposition, referring to page 6, beginning at line 4, how much work do you have to date, approximately, and answering, I don't know, probably less than 10 hours. So as of November 2018, you were saying you already had some amount of time, just less than 10 hours. You told the jury a few minutes ago you have 8 to 10 hours total, and now you've indicated that you've got over that just since the deposition, correct? So it's really, we're talking about closer to 30 hours worked as opposed to 8 to 10.
That was November of 18. It's been a year since then. Again, I don't have any of that information in front of me. I'm pulling this from memory and based on results. If it's 20, if it's 30, I have records that I keep so that I can accurately bill.
Yes, sir.
But I don't have those with me. I don't travel with them.
And I understand that, which is why I say the exact number is not important. If it was 8.3 or 9.6, no big deal. But when asked on direct examination, you answered under oath that you'd worked 8 to 10 hours, and now it seems you're saying that number's probably closer to 30 hours, which you would agree drastically increases the amount of money you make on the case, right?
Well, I charge less when I travel. I don't charge $250. I charge $150. And I answered based on the analytical work that I did, not on travel and other material.
Well, even in that event, then, you said that the analytical work is an additional 8 to 10 hours since November of 18, right?
No, I meant in total on this particular piece of work.
So you didn't understand the question when I said just a second ago how much analytical work since November of 18?
Again, I interpreted analytical work to mean actual work on data and calculation.
Yes, sir. That's what I mean.
That's what I said.
I'm talking about the timing, though, not the type of work you're doing.
Object, get argumentative. Just saying.
Okay, so let me ask you a couple general questions about DNA interpretation. What is SWGDAM?
The Scientific Working Group on DNA Analysis Methods. It is supported and administered by the FBI.
And what does SWGDAM do?
They produce guidelines for various aspects of DNA testing. It's a group comprised of state lab directors and other people in law enforcement that are doing DNA testing.
And does SWGDAM identify guidelines that accredited labs should follow to make sure that they're producing reliable results?
Yes.
Okay. is one of the things that SWGDAM requires is that any accredited lab develop interpretive guidelines for use within their lab. Is that correct?
Yes.
Okay.
One of the recommendations is that each laboratory develop its own set of interpretation guidelines, which is why when I mentioned earlier, we have various cutoff values that have a range, not a single number across the United States.
Right. And so those numbers would be based on what each individual lab determines to be a reliable threshold based on the instrument that they're using, right?
That's correct.
Okay. So to be clear, SWGDAM doesn't issue interpretive guidelines itself. Is that right?
No, it offers oversight in terms of what things you can do, and it does have a series of guidelines that it says you should consider, but they're not laws by any stretch of the imagination.
One of those guidelines is that if you're interpreting data developed in a particular lab, you're supposed to use that lab's interpretive guidelines, correct?
To a point, and that's why they're called guidelines. The guidelines are meant to serve as reference points for the analysts in that laboratory that are working under the training that they've received from that laboratory. They are not meant necessarily to extend to the field as a whole.
No, not meant to extend to the field as a whole, but they are meant, and when I say they, I mean the interpretive guidelines developed by a particular lab, they are meant to apply to any analysis being done on data developed from that lab, correct?
Yes, and as you point out, they're guidelines. So there are rules and there are even procedures in place within laboratory systems that those guidelines can be set aside when necessary by using, there's paperwork to be filled out, of course, but you can get exceptions to the guidelines because it's impossible to write a particular rule that would cover all of biology because literally every sample can be unique and there's no way to legislate that. So what we have in laboratories are methods by which exceptions can be granted.
Generally, the purpose of a requirement that you follow the interpretive guidelines developed and validated by a particular lab is because that's what the lab has said based on their tests with their specific instruments. This is what the reliability threshold is. Is that generally true?
For their analysts and the training that they've received, yes.
And more relevantly, for their instruments, correct?
Well, every instrument that you see will be slightly different, and even instruments over time will change. And so you have to, you have to consider things like the age of the laser, for example. But again, it is for their system, for their analysts and the way they're trained.
Okay. As an example, did you take into account the age of the laser used to develop this data set?
It didn't seem necessary based on the visualization of the data. It seemed clear enough that the laser was probably working just fine. Typically on older lasers, you get intermittent issues, and I didn't see that in this data.
One of FDLE's interpretive guidelines that was validated for use with Profiler, which that's what we're looking at, right? The Profiler page?
Yes.
One of the rules is that you can't do inclusion statistics where the RFU value is less than 100, correct?
That is one of their guidelines.
Okay. And that's a guideline for interpretation that was validated internally by FDLE for their labs, right?
For their analysts with their training, yes.
And again, more important than the analyst training or experience, validated for use with that specific instrument, correct?
Again, yes, but that's part of their system. It's part of a whole system. It's not just you can't just sort of uniquely pull that out.
Explain what developmental validation is.
Developmental validation is when you've developed a brand new system. You have a brand new genetic marker, you have a brand new piece of equipment, you have software, something that you're using that you are the first person to develop it. And so you go through and you do a validation to show that it actually works the way you say it's going to work. And there's a series of guidelines that you follow for developmental validation. After that, there are two types based on whether it's equipment or reagents. You can do what's called a use test to show that the equipment is working the way it's supposed to be working. That is, you have 10 of these machines and you buy machine number 11, you do a use test to show that it's working. Or you can do what's called an internal validation, which is really a redo of the developmental validation, but now on something that's already completed.
Okay, and developmental validation for a specific kit, like Profiler, that's totally different than what you did identifying and developing use for particular loci, however you say it, correct?
Loci.
Yes, sir.
No, we performed developmental validation on a number of items when we were developing them. At that time, we weren't using them as multiplexes like they're used here. We didn't have that capability. And we were using them as what's called monoplexes. So instead of running one reaction and getting 12 results, we were running one reaction and getting one result. So we'd have to run the test 12 times. But at that point, Bodie wasn't a reagent company, and we were working with the reagent companies, and they took over and produced the product.
Right, that's my point. I'm just trying to clarify that developing and identifying loci that you want to use for interpretation, figuring out how the molecules present at those loci work, that's a different process than the practice that companies have to engage in to developmentally validate their instruments, correct?
No, it's largely the same between instruments and reagents at the time you're actually developing those things. And like I said, even though we were doing monoplexes, we did developmental validation on those prior to the reagent companies taking them over. But I don't think I understand your distinction, perhaps, but we did a lot of work on those.
Your work was primarily focused on the science of the DNA itself, as opposed to getting a particular kit to market, right?
Oh, most certainly.
Yeah, and so the focus of your work is on understanding individual loci, understanding individual molecules, frequency of occurrence within genetic populations. That's the stuff you were focused on, right?
Certainly.
Not so much figuring out how to make sure one particular product, a kit, is reliable for use in lab testing, right?
Well, at that stage, I was certainly concentrating on the population genetics and the molecular genetics.
Right.
Excuse me. Once the kits were built, then we turned around and did validation on those kits in our laboratory for our use.
Right. That wasn't Profiler, though. You didn't participate in the company's developmental validation of Profiler, right? Not
in the company's developmental validation of Profiler. Only after Profiler was released as a commercial kit.
Right.
Then we validated it for our use.
For your lab, as required by SWGDAM, right?
Yeah. Well, SWGDAM didn't exist then.
Okay.
So it was before that.
Gotcha. So you guys were kind of doing the same thing back then that is required of accredited labs now, which is you have to validate interpretive guidelines for use with whatever kit you're planning to use for testing.
Yes.
Okay. Similarly, labs go through a process of I think you already referenced this, labs go through a process of internally validating, separate from the developmental validation, interpretive guidelines for use with particular kits, right?
Yes, certainly.
And the purpose of those internal validations is to ensure that based on the procedures that lab is teaching and carrying out during testing, that the instrument is going to produce consistently reliable results, right?
Yes.
And you didn't have anything to do with the development of FDLE's interpretive guidelines for use with Profiler, correct?
I did not.
Okay. I want to ask you about the timing of the opinion you're offering relative to State's Exhibit 63, the swab of the bath bar. When were you first brought into this case to consult with the State Attorney's Office?
In 2016.
not 2011 by Mr. Campbell?
Oh, excuse me. I may have just misspoke. Yes. No? Hold on just a moment.
Yes, sir.
No, I was correct. It was March of 2016.
So if you previously offered testimony indicating that you were first retained to work on this case back in 2011 or 2012, that would be incorrect?
That would be incorrect.
Okay. And if you previously testified to that fact under oath, you would agree that that testimony would be inconsistent with the testimony you're offering now?
It would be inconsistent. I apologize. I do my best when I'm working on cases to keep things straight, but the exact date that somebody asked me to start working on a case doesn't always stick very well.
I understand. You would agree that there's a significant difference between 2011, 2012, and 2016, right?
I have the letter from Mr. Campbell on 2016. If I said 2011, then I misspoke.
Okay. What Mr. Campbell was initially looking for was to have you review FDLE's findings as it related to complex mixtures, correct?
Correct.
And you agree that this sample that we're looking at, the electropharogram for the swab of the bath bar, is a complex mixture, correct?
It is.
Okay. You didn't offer the opinion that you're testifying to now, however, until sometime in the fall of 2017, correct?
I believe that's correct. I don't have any notes on when I first offered that opinion. I don't typically have any information about cases or what samples are relevant typically.
No, you're just provided a big stack of documents relating to the analysis, the DNA summary charts, the electropharograms, all that stuff, right?
Yes.
And that's called generally, when you get it from FDLE, their biology file. It's going to be a big, thick file depending on the number of exhibits, and it will have all that information, right?
That's correct. It's the biology file or the case file.
Right. And so to be clear and help the jury understand what it was Mr. Campbell wanted you to do, he wanted you to use your experience working with complex mixtures to see if any analysis beyond what FDLE had done could be done, right?
Yes, he wanted me to look at this information and review it and help him understand it as well.
Right. And after reviewing that information, you offered Mr. Campbell your opinions about any exhibit or exhibits that you could offer additional analysis on, correct?
Yes.
And that did not include this exhibit, number 63, correct?
I don't specifically recall, and I don't have any notes to what we had a discussion about, and I don't have any way to know, because of the nature of what he asked me to do, what material or information was even germane to the case. So I offered my opinion on a lot of different things, but I had no idea whether they were even relevant to the case.
As a further example, it wasn't until fall of 2017 that you reported your statistical findings 700 billion times more likely to include Mr. Segura, the twins, and Brandy Peters than other people, right?
It was approximately that time frame or a little later.
And that was after and in response to someone from the state attorney's office calling you and asking you to look at this specific exhibit and see if you could do something else with it, right?
Yes, I was contacted and told, could I review this and look at it again?
And this was part of the initial biology file.
Yes.
And yet, at no point prior to fall of 2017, after you had been retained, did you offer an opinion about this? It took somebody from the state attorney's office calling and asking you to do something different as it related to this specific exhibit, correct?
Of course.
Okay. I want to ask you about some general principles then that are employed by you and other analysts during interpretation of a data set. Is it generally true, and I understand you're going to say you got to look at the sample as a whole, is it generally true that if you're looking, for example, at a clean two-donor mixture trying to identify the major and minor contributors, one of the things that you'll look at is proportional peak height.
Yes.
Okay.
And that's relative to other peaks.
Right. And so as an example, if we were looking at a sample and trying to identify major and minor components, we might have the major contributors RFU values up around 1,000 and the minor contributors down around 200, just as an example. Is that right?
That's certainly possible, but it doesn't necessarily, each of those conditions can be different based on the length of the DNA that you're analyzing and also the overall quality of the sample.
Right. Just as a general matter, though, those peak proportions, like, for example, if I'm a person that has a 12 and 13 at D3, you would expect my peak proportions to be relatively similar on any data sample developed using my DNA, right?
Not necessarily.
Isn't it most common that that's the case? Like there's going to, the FDLE has calculations that they do for percentages, and if the peak heights are too different, then they aren't able to say they're from the same person. The peak heights have to bear some proportion to each other in order to be called as being from the same person, right?
There are labs that do have that interpretation guideline. The problem with that is there are several scientific papers where we know that the substrate that the DNA comes from can influence significantly the quality of the results. Specifically, metal surfaces can have that problem. So that the process that we call PCR, which is polymerase chain reaction, which is literally the molecular Xerox machine that we use, will be interfered with by metal ions, okay? And so we can get significant imbalance in the DNA peaks from the surface that it comes from. We can get imbalance in the peaks simply by the fact that if there's not very much DNA in the sample, and you can tell that when you have low RFU values, then what will happen is literally as the Xerox machine starts, sometimes it'll miss that page on one round. And the way PCR works is it makes a copy, then it makes another copy of the original and a copy of the copy. So you go from 1 to 2 to 4 to 8 to 16 in your progression. But if it misses one of the peaks on the first one, then those volumes lag. And so you'll get imbalance just as a function of the PCR process itself. And then, of course, there can be other things in the material or the surface that can interfere with it. And all of those go into how you look at the results when you see them, which is why, as I said earlier, typically the electropharogram is the story of the sample.
I understand that there are circumstances that may cause peak heights from a single individual to be out of proportion with each other. But as a general matter, FDLE's interpretive guidelines require, in order for an analyst analyzing data developed within their lab on their kits, in order to call two peaks as being from a single person, they have to have a percentage-based proportional relationship. Correct?
That is in their guidelines, yes.
Okay. Let's talk about the specific loci you identified as places where you were going to do inclusion statistics for this sample here. You did it at D3, VWA, D8, D5, and D13, correct?
Yes.
Okay. And there are no allele at D3 that are foreign to the 4 victims, correct?
Yes, everybody has 15s or 17s.
Right. Same with VWA. There's no allele there that are foreign to the 4 victims.
Let me explain the individuals you're asking about specifically when you say 4 victims.
Right. So Brandy, Tanai, and Tamai have the same DNA, right?
Right.
And then Javonte.
Well, Javonte, yes. Okay.
So there's no DNA at VWA that's foreign to the 4 victims, correct?
That's correct.
And similarly at D13, there's no allele that are foreign to the 4 victims.
Yeah, excuse me, yes. D13 is right here, and you can see everybody shares 11 and 12, and those two are very common alleles in the population. It's like having brown and blue eyes. So I'm not surprised that here we have a combination of 3 people, but only 2 alleles.
Let me just clarify your answer as it relates to D13. The 11 and 12 are allele numbers that the victims do have, correct?
They do.
So there's no foreign allele number showing up at D13?
No, everybody shares the very same data set.
Right, okay. So the 3 loci we just talked about, D3, VWA, and D13, there are no foreign allele numbers, correct?
I'm trying to make sure I understand your question exactly.
Let me rephrase that. That wasn't very precise. At the 3 loci we just talked about, D3, VWA, and D13, there are no allele numbers showing up that are foreign to the allele numbers the victims have at those particular loci.
That would be correct.
Okay. The other 2 loci, there's D8 and D5. There you were able to identify a couple of foreign allele numbers, correct?
Correct.
And so there's 2 allele numbers in the entire data set that are foreign to the victims, right?
There's 2 sets, yes. But for example, in D5, there's this 12 right here. Mm-hmm. And that's a unique peak to one of the individuals, Mr. Segura.
Or any number of other people, correct?
It could be other people, but you notice that in the case of Mr. Segura, he's a 12-16. I'm talking about D5 or D? I'm talking about D5. He is a 12-14. Mm-hmm. That's these 2 peaks right here. And those are separate from Brandy Peters and the twins.
But not, I'm sorry, as it relates to the 14 is not foreign to all 4 victims. Javonte has a 14 at D5, right?
He does, but he has an 11 as well, and that 11 would be with the 11 from Brandy and from the twins. So what we have, and as you talked about a moment ago with your balance, you see this 12 and 14 relatively balanced, and this is a low RFU sample, so relatively balanced and set off by themselves, unique from the other individuals. So this is sort of a hallmark that you can look at and say, okay, I have something here that's different enough that I can interpret that.
Well, when we're dealing with RFU values this low, it's totally possible that Brandy's 11 would be masking Javonte's 11 at D5, right?
It could be.
Right. So the only number at D5 that's foreign to all 4 victims is the 12 there, right?
That's correct, and that's but Mr. Segura has that 12.
Right. Okay. And so the other foreign allele in this data set is at D8, correct?
That's correct.
That's 16.
That's correct.
Both of those allele are starred allele, correct?
They are low intensity alleles. That's correct.
And under the FDLE's interpretive guidelines, you're not permitted to do inclusion statistics on low RFU value allele, correct?
But you'll notice that they still have their computer call that allele. Okay, so they know they're saying it's above their analytical threshold. So it's still called. The fact that they don't interpret it is part of their guideline, but they still recognize it as real data. And that's the issue. That's why we have what's called an analytical threshold versus a stochastic threshold. For them, stochastic threshold means that, like when you drive down the road, it says, careful falling rocks. It means pay attention, there might be something going on here.
So let's clarify in real people talk what you mean there. You're talking about the 2 different thresholds for inclusion and exclusion, correct?
I'm talking about the two different thresholds for whether or not we believe the data is real versus whether or not there may be additional loss of information as a function of the low RFU value.
I think we're saying the same thing. Just to be clear, FDLE had an interpretive guideline as it pertained to Profiler, saying that you could call for exclusion purposes peaks above 50 RFUs, whereas to do inclusion, the peak would have to be above 100 RFUs, correct?
Well, typically, and throughout the field, you can call peaks of almost any RFU value if you're going to exclude. The 1996 National Research Council report makes it clear, and SWGDAM has always said that even if you have data below what you consider to be the analytical threshold, so the analytical threshold says that below this line, we don't think the data is real. It could be just noise in the signal-to-noise ratio. Above this line, the data is real, okay? But always, even below the analytical threshold, if there appears to be information there that would exclude somebody, you can always call it for exclusion.
That's not really the question I'm asking, so let me try to be a little more precise. FDLE's validated guidelines, interpretive guidelines, that were validated for use with Profiler permitted exclusion above 50 RFUs, but prohibited inclusion below 100 RFUs, correct?
They would not use that for statistical work, but typically what analysts do, and certainly the way I teach them, is that even though you may have data that is below what you would use for inclusion, it still must nonetheless be consistent with your overall result.
To be clear, though, you used for inclusion purposes allele that were less than 100 RFUs, which in theory would violate FDLE's interpretive guidelines, correct?
I used that information. That is correct.
Okay. And to be clear about what you were looking at when you did your interpretation, you looked within the four corners of this electroparagram, correct?
That is correct.
To interpret this electroparagram, you didn't look at any other electroparagram or consider DNA on related surfaces from the crime scene, correct?
No, of course, you don't do that.
Right.
That you cannot do. I had this information, and as the prosecutor put up a few minutes ago, the blow-up color diagram as of the same information, so that I could look down at the baseline area below analytical. Okay.
You would agree that if Javonte is a contributor to this mixture, that would drastically alter the statistical likelihood that you reported, correct?
If he was, then we wouldn't be able to use as much of the data because he has missing data. So you would have to use fewer loci to do the calculation, which would mean you would have fewer multipliers. And that is exactly as it should be, because if somebody's not included, then the mixture statistic ought to be very low to the point of not useful.
And the reason that you didn't want to say Javonte was included here is because that would have required you to find that there was dropout. In other words, that certain allele numbers for him were falling off the electroparagram, right?
No, I had already determined that there was, in fact, dropout. There was no, I was not trying to include or exclude anybody. I was letting the data speak for itself.
So to be clear about that, there is prevalent dropout all through this sample, right?
There is dropout in this sample.
Okay, because you're saying that there are 3 contributors. Well, technically 4, I guess, since the twins have the same DNA. But you're saying it's Brandy, it's the twins, it's Mr. Segura.
That's correct.
And to be clear about that again, the only allele that are foreign to the 4 victims, which I understand you're saying Javonte's not there, but the only allele that is foreign to the 4 victims is that starred 12 down at D5 and the starred 16 up at D8, right?
That is all we have for this data set, and given the limited nature of the data set, it's significant.
Generally speaking, if they reran this on Profiler, would that data set be relevant to you as well, if you're trying to interpret this and determine who's contributing, who's not?
It may well be. It's very difficult usually with low-level samples. you'll get some things that'll come up and go down. You have to consider the data that you have.
Which is why you say you're looking at the four corners of the page, correct?
I'm looking at this result. This is the raw data.
And it's probably obvious and goes without saying, but if you were only to use the foreign allele identified, that is, allele numbers that are foreign to all four victims, of course, that would obliterate the statistical report as well, correct?
I'm not sure I understand your question.
If you don't use locus where foreign allele are not showing up, which is to say, if you don't use a locus where only the victim's numbers are present. Follow me so far?
No.
Okay.
I'm sorry.
So the only two locus here that we have foreign allele numbers are D8 and D5, right?
Right.
And so the other three the other three locus that we talked about, D3 VWA and D13, there's no foreign allele numbers present, correct?
No, but the group of alleles still have the same individuals. So all the individuals' information is still in all those locations.
The hypothetical, I guess, that I'm trying to ask is if you eliminated the three locus where there's no foreign allele numbers, that would, of course, impact the statistical finding, right?
Anytime you eliminate loci, it's going to impact because you multiply each result by the next result. Because what you want to know is the collection of results together.
Yes, sir. Thank you. I have no further questions.
Redirect. Yes, Your Honor.
Mr. Prince pointed out the D5 and D8 here. In looking at an electropherogram, are you looking at each individual loci at a individual time? In other words, I'm going to look at D8, interpret that, then I'm going to look at D5, interpret that, then I'm going to look at VWA and interpret that. Or are you looking at as a whole?
You look at it as a whole. So the first thing that I do in any case, I don't care how big the file is I pull the electropherograms out and look at them. I don't even know what the electropherogram is other than it has, in this particular case, an exhibit number, the number from the collection of the data, whatever that number is. But all I know about that sample at that moment in time is that it has a sample number.
Okay.
I don't.
So we've been talking about this being a sample from the grab bar. That was not part of what it is that you initially would have looked at on this. All you know is it's an electropherogram and it happens to have an exhibit number, correct?
That's correct.
Okay.
So at that point, then what I'm looking for is the story of the sample, about how much DNA is there. Is it a mixture? Is it a partial profile, which this clearly is? That tells me a lot about the sample before I even know what it is. So I'm looking at it as a whole. And then, in fact, I don't even know who the contributors may or may not be at this point, simply that I have that data. And as you can see, what you have for each of these peaks, they're fixed, right? There they are for everybody to see. They're not going to change. Nothing's going to change. Just the question becomes, where might they have come from? And so at that point, then even when I know, for example, that I have limited data here, this says FGA up there, and I certainly expect to have, because I have very little here, I don't expect to have much down here at D7 S820, and sure enough, I don't. You can see that there's some things down here in the baseline, which is what I looked at the other thing for. But overall, that's the story that I've seen. Now I have the story of the sample, and then I can start my comparisons.
Okay. And then whenever you're doing comparisons, at that point you start looking at each one of these loci and then how they impact all of it together, but also as an individual aspect as well, correct?
Correct. Even at the point at which I'm making a comparison and I make the decision that this person appears to be in the mixture, even where I have incomplete data, if there's anything there at all, what I see still needs to be consistent. Now, I won't use it for statistics at that point, right? I only used 5 markers, and there's clearly 9 markers there, right? Because that data was incomplete. So that didn't count against whoever I was comparing. And then you simply go through the reference samples that you have. And again, what you're looking for is places where you have some uniqueness that says, this person's unique to the other people, and there they are. That helps establish what you think your overall interpretation is. That's one of those fine points you look for that sort of helps solidify that.
Okay. So when we go to D8 here and we see these 4 different numbers there, the 11, the 15, the 12, and the 16, that's one of the locations you're looking at and where you're doing for and looking for uniqueness of this particular loci, correct?
That's correct. That's a location where there was a unique marker that somebody needed to have if they were in that sample, and that was a location that we talked about that Mr. Segura had a unique marker.
Okay. And that would be number 16, correct?
That's correct.
And Mr. Javonte Segura, the young boy that was killed during this, does not have a 16, correct?
He does not.
Okay. So even, and I see that the RFU on this one's a 74, so it's a low RFU.
That's correct.
But even by FDLE standards of low RFU calling, they can use that for exclusion purposes, could they not?
They could.
So at this point, Mr. Javonte Segura should be excluded regardless because that number doesn't exist for him, correct?
For him, that's correct.
Okay. So even by FDLE standards, he's not there.
That's correct. Now, they have a little bit of a conflict because of this being a complex mixture. They have a number of other restrictive guidelines that keep them from being able to do lots of interpretation here.
Okay. And let's talk about those guidelines. But bottom line is, in this case, that 16 right there tells us right then and there, Javonte is not present here, and that 16 is, in fact, unique as far as these persons go to Mr. Henry Segura.
That's correct.
Okay. Now, there are interpretive guidelines. We talked about those, SWGDAM.
Correct.
Okay. SWGDAM are guidelines for the lab analysts to ensure their results are accurate given the average ability of analysts.
Yes, each analyst, when they're hired by FDLE and all systems, they're put through a training program, and that training program teaches them how to, everything from how to handle the evidence as it's received in the laboratory at their bench, to returning the evidence, how to extract DNA, how to run the DNA on their equipment, and then how to interpret the results as they get it. So, these are people that typically, I think the requirement is they have to have a bachelor's degree in one of the sciences like biology, chemistry, physics. They can have math. They have to have certain undergraduate course requirements and meet a certain basic standard.
And there was a lot of terms thrown out there, and I noticed that Mr. Prince called them SWGDAM rules, and you're calling them SWGDAM guidelines. There's
Yes.
a difference between the two, is there not?
Yes, this is, kind of like the Pirate's Code. I mean,
Stole my line.
Sorry.
You stole my line.
I apologize. That's, I give it back to you. The fact of the matter is, we can't legislate every possible condition that's going to happen in biology. And if at the moment we try to, we have to violate that. So rather than create rules that just are impossible to follow, then we create guidelines that allow people to act within those boundaries as best they can.
Okay. And those SWGDAM guidelines are established for the purposes of governmental labs, taking into account the training experience of the analysts that are conducting those as well as the equipment, correct?
That's correct.
And in fact, when they're setting up those guidelines, they have to not only account for the ability of the analyst that's been there for 10, 12, 15 years and done countless number of analysis, but also those that have just come out of the training program and only been there for 2 years.
Certainly.
So that guideline actually is a average, if you will, of all that experience in order to make sure that the governmental lab ultimately produces a reliable product or reliable test results, if you will, based upon those analysts, including the ones that have just come off the training.
Certainly, and in a large system like FDLE, there are Florida law enforcement labs in other areas of the state. So this is a very large organization with multiple labs and multiple analysts across a broad geographic area. So they have to manage all of that in a single system.
But as we said, they are guidelines, and certainly someone with your experience can look at those guidelines and make determinations even outside those guidelines would be proper?
Yes.
And why is that?
Again, it's having the additional experience and training and having worked a long period of time with lots of very damaged samples. I mean, in a lot of ways, that's been my specialty over my career. And I've developed guidelines, I've developed analytical thresholds, all of those things. I've worked within those systems and helped do some of the initial DNA sequencing on some of these. So I have a breadth of knowledge that not a lot of people would have.
Now, some other issues were made about when you first were contacted on this, and you were initially contacted by Jack Campbell, who was handling this particular case back in 2016.
Correct.
Okay. And at that time, you were actually contacted and asked to look at an overall picture and analysis and whether or not Florida Department of Law Enforcement were complying with the discrete dam rules and things of that nature and making that initial analysis, correct?
Correct.
Okay. And it wasn't until, not to throw Mr. Campbell under the bus, but it wasn't until I took over in the case and contacted you and we had communication in 2017, I asked you to specifically look at this mixture and give me any interpretations that you could give, correct?
That is correct.
Okay. And at that point, that is when you started making the analysis as it relates to this particular sample.
Yes.
And in making that analysis, applying all the information that you have over your long career, your developmental aspects, the development, quite frankly, of the industry, it's your determination that Henry Segura's DNA is present in this and Javonte Segura's DNA is not, correct?
That is correct.
To the exclusion of, in the likelihood ratio is 1 in 700 billion.
That's correct.
No further questions.
All right, any juror have a question of this witness? All right, you can step down. He's subject to recall, I understand.
He is, Your Honor.
All right, you ready to do your recording?
We up there, I'm going to swap seats with him.
Yes, sir.
I'm sorry, but I do have.
A question of this witness? Okay, I'm sorry, write your question down, please. So the question that was asked was whether his analysis was reviewed by anyone else. It would not be appropriate to ask this witness whether somebody else reviewed and approved or disapproved his results. You may well hear from some other analysts that offer their opinion, but it would not be appropriate to ask the witness that question. All right, you can step down, sir. All right, now we're going to have the recording.
Yes, sir. Permission to publish 124 and 124A at this time?
You may.
For the record, Your Honor, when we first heard it this morning, we listened to what is the second page of the transcript, and this recording is going to start on the third page of the transcript, the top of page 17.
Okay. You have a transcript I can follow along with.
So this recording, the part of the recording we're about to hear starts at the top of page 17, the third page of the transcript. This morning when we first started, we heard what is the second page of that transcript. It says page 2.
Portion of it is inappropriate and they're not reactive.
So we are starting at page 7?
Yes, sir. Top of page 17.
Okay. So some parts have been taken out. That's by agreement of the parties. You shouldn't be worrying about what's been taken out. It was just taken out because it's irrelevant. So you may proceed. We're on the top of page 17, to my understanding. Okay.
After you stated the unstable man, all I give up to you, all I do for you, I'm going to be double sick. You don't love me.
I do, man.
No, you want this bitch over here and why he did shit for you. What you don't get to you?
Let me happen.
What?
Let me happen.
How? She made you have to bring it to the soul, huh? What? Huh? What? Well, I guess I need you to sit up so you can get home.
That's how you feel.
No, that's what you're making it seem like. You don't fucking need me. You don't care about me. Because I'm the one holding it down for you. And so when you come out, you can say I have something. But you want to take it and go over there.
I'll take anything, but when I get out of my work, right?
You're going to get out and you're going to be with her. That's the other one that gave up the most. You don't understand how much I love you, but you don't care because you love her. And I'm just an afterthought.
Giving up stuff too.
What you giving up?
She said she's gonna go back in her mama, break her lease, so that she can help pay for the lease fees.
Whatever. I don't have nowhere to go with you. We don't have nowhere to go. We don't have nobody to help.
I was thinking, if she moved back in her mom, you could move in or whatever she lives in. You would have to break her lease, you would have to get a new lease.
How much is she have left?
I don't know.
In the apartment?
Yeah. Townhouse. 2-bedroom townhouse. So you can afford it, she can afford it. And they both my name up.
But I think you love her and I love you.
So what?
How can you love her when I love you? What?
That's it.
How could you? I can't you get out and come on us.
Summer field, still come home and see them.
What?
Still gonna come home and see them.
Don't be with us.
Why don't we just worry about me coming home right now?
Because I wanted to know you would be with me.
What difference do it make?
We're separate. I'm sacrificing so much. We're suffering over here. I'm suffering for somebody who don't want me. You know that makes make you feel? Huh? What? I can't hear you. It's unfair. We have nowhere to go. What? I don't have any good credit. I don't have any money. I don't remember where to go. Yes. Someone else trying to look at me and say, what they going to do now? And I don't know what to tell them. Not when they stuck up out of car and try to look at me and say, what we going to do now?
I'm telling you right now what you be doing. You be doing it right now. You should be on your internet, on the computer there, and working looking right now.
Looking for what?
What do you mean looking for what? What are you doing? Right now?
Never so pretty.
What are you doing? Right now?
I'm cooking them to eat. They're hungry.
Well,
What?
cooking, you should be on your laptop.
So we're not looking at it. Looking out for it.
Well, for a minute, it's just $40,000 a year.
But I don't bring home that much.
What you bring up?
What?
She makes the something with what you bring up?
And what about my credit issues? I have terrible credit. Who will take a chance on me?
I don't think that's gonna be an issue.
What?
I don't think that's gonna be an issue.
It was an issue before. And I had to pay extra security deposits. What?
Well, you're not buying stuff when I'm moving my day. Doing what you want.
They probably would let me take over her lease and my credit ain't good. Huh?
Yeah.
What?
I don't know.
I don't know. If I gave up my life for you, they could tell us what else. God had a 30-year life.
Looking like the day was nice to you.
Huh?
It was looking like the day was nice to you.
I said it was
It was looking like that day was nice to you. Sure, think it'll be okay, right?
You may. You just pass the transcripts down. Next witness.
All right, this time stay with rest.
All right. Once we get the transcript, we'll let the jury step out. Everybody be seated. to be heard, Mr. Prince?
Your Honor, at this time, the defense would move for judgment of acquittal. Based on the evidence produced by the state, I would suggest that this is a circumstantial case, and the evidence presented is insufficient to make a prima facie case that is inconsistent with every reasonable hypothesis of innocence.
Excuse.
Your Honor, it's not a circumstantial case. We have Dr. McElfresh's testimony placing the defendant's DNA on the grab bar directly above where the children were found murdered, as right next to a blood swab that was Brainy Peters' blood that was there at the same, or in approximately the same location. In addition to that, given the fact that he repeatedly lied to law enforcement as to his whereabouts, and the law enforcement proving where his whereabouts are would in fact rebut any kind of reasonable hypothesis in a sense at this time, and would ask for a denial.
Further, Mr. Chief?
No, Your Honor.
Further, Mr. Prince?
No, Your Honor.
I deny the motion for judgment of acquittal. In a few minutes, get ready.
Yes, sir.
What, 10 minutes? No.
Yes, sir.
And Your Honor, earlier we presented the perpetuate testimony of Mr. Avila. Page 25 is in fact the objection that is relevant. I am going to ask that you may end up wanting to elect to actually watch and listen to that particular statement. So I'm going to give you that disc because it is an argumentative aspect, and I believe that's most reflected by the actual video and tone of voices and the banter that's going back and forth.
Doesn't, but there is no objection to the question that's asked. The question, I mean, if you're asking me to strike the initial part of it where there's an objection, as the length of questions, that's what you're talking about?
He asked a question, Your Honor, before there was an answer from the defendant. My objection was that the question was in fact argumentative, and he went on and continued that with the answer to the question. He had to rephrase it for request of the defendant, but I mean for the request of Mr. Avila. But
well, there's no objection to the question that he actually answered.
No, he rephrased the question that was asked. That was the objection. He asked for rephrasing, and he rephrased the question, and that was the rephrased question was the one that was objected to.
There is no objection to the rephrased question.
I would submit that the objection when he first asked the question is the same. Regardless, I would make an objection.
If you're asking to strike lines 8 through 17, where there's a question asked and then you object, and he says, I haven't understood what was asked, we can strike that. There's not a question asked, but there was no objection to the question that was asked. Now, y'all didn't make crystal clear whether you were preserving objections or not.
Your Honor, the question that was asked was, well, Mr. Avila, did it cause to take it's line 8 through 11, and had been repeatedly asked at that point. I made the objection then that they would object to the question as being argumentative. He told me he can go ahead and answer it, and then he rephrased it. So I would submit that the objection applies to that question as well as the one that was rephrased on page number 19. If I did not make that clear in the transcript, I am objecting to it at this time.
Mr. Prince.
My position, Your Honor, is that the rephrased question was not objected to. And even if it had been, the rephrased question was not argumentative. So I would submit that it's a proper question and answer.
Well, I don't think it's relevant in any way as to whether he made long answers or didn't make long answers. Really doesn't have much to do with anything. I'll sustain the objection at this point with strike line page 25, line 8 through page 26, line 8. thus sustain that objection.
Thank you, Your Honor.
Is that the only objection you want to be heard on?
Yes, Your Honor. The second one, Mr. Prince rephrased it, and I think that took care of the issue.
Okay. You did ask me to rule on two defense witnesses. Ms. Timmons, I'll overrule the objection as to Ms. Timmons. That does not mean that the letter is admissible. I'm not saying that the letter is admissible. There is some testimony, and I'm going by what she did last time. To the extent it's the same as last time, there is some discussion about what's on the outside of the envelope. I'll overrule the objection to that. I make no ruling as to whether the letter is admissible or not. That's not before me at this point. As to Mr. Griffin, I've reviewed his testimony. You're going to have to clue me in, Mr. Prince, as to what's relevant. He really only says four things. He says he's dealt drugs with Mr. Paramore. He's never dealt drugs with Gregory Washington. He knows who Kenny Green is, but never dealt drugs with him. And the police recovered guns at his house. When you narrow it down, all down, that's what Mr. Griffin testified to. So tell me what's relevant from that.
Yes, sir. So Mr. Santos will assert as part of his testimony that Mr. Paramore and Mr. Griffin were recruited as local members of the group that was going to carry out the murder. And our assertion is that Mr. Paramore and Mr. Griffin's motivation, their willingness to do that, was based on the fact that Brandy Peters was Kenny Green's girlfriend at the time. Mr. Griffin repeatedly lied about his knowledge of and relationship to Mr. Green. The full transcript of the testimony reveals, first he claimed he didn't know who Mr. Green was. Then he claimed that he only knew him from seeing him at jail. Then he claimed he knew who he was from seeing him around town. Then he admitted that he did in fact know him. And finally he admitted that, yes, they were drug dealing associates and had a falling out. The fact that
he said what?
That Mr. Green and Mr. Griffin were drug dealing associates.
He doesn't say that in the trial testimony. If you find that, give me a page number and a site. I don't find that.
I'll have to find it after the break.
He clearly says he had no drug dealing with Mr. Green, based upon what I read.
Yes, sir. I'm just speaking from my recollection. My recollection was that he was impeached with.
Well, you'll need to show me that.
Yes,
I
sir.
just read it. I don't find that.
Yes, sir. In any event, the progression of his statements pertaining to his relationship with Kenny Green, the fact that he's lying by itself is relevant to establishing the motivation for being involved in the murder to the extent that witness Santos says they were involved.
I'm also saying the state's objection, unless you find something that where you want to correct what I've found, that he said he did not deal with Kenny Green. That's the testimony as he testified at trial. If I've missed something, you need to point that out to me. But other than that, I don't see where there's any relevance. I mean, you impeached him with some things, but ultimately his answer was he had no recollection of dealings with Mr. Green. The Green did have a baby with his ex-wife's sister, that his ex-wife and he were separated at the time and he was in jail. So that really has no relevance.
Ms. Baker is referring me to the part where I was impeaching him regarding his business relationship with Mr. Green. It starts on page 24 at the bottom and proceeds, it starts on page 53 at the bottom and proceeds on to page 54.
Well, the fact you're impeaching him that he may have said something different sometime doesn't make his testimony admissible. If you have something that shows, if you have it where he says, yes, he was dealing, I need to see that, but I don't think he said that.
He doesn't say those words, but I'll read the exact answer he gives to that question.
Let me have the transcript.
Yes, sir. May I approach?
What you're relying on. So he says that's what the document says. I'm not asking you what the document says. Now I'm asking you whether you did. I can't really recollect that I remember doing deals with Kalo, period. So that's his answer. I would sustain the state's objection.
And Your Honor, given the court ruling on Ms. Timmons, we would do a motion to eliminate for the letter itself to be excluded. If there's any questions that are asked about the letter, the natural inclination of the jurors will be they want to see the letter. The letter isn't admissible, so we would ask that there be no reference regarding the letter itself or who it was from. If there's an envelope, again, I don't know what that would do. I understand the court ruling on that one, but the letter itself, we would object to any reference to it or admissibility of that letter.
Well, I'm going to let them do what they did last time, which was refer to what was on the outside of the letter. You said, Mr. Prince said the contents of the letter didn't mean anything anyway, so are you trying to get the contents of the letter in?
Last time, Your Honor, I wouldn't have been able to offer any testimony about the contents and what it actually meant. Since Santos is testifying live this time, I don't think that it would be inappropriate for him to testify as to what he was trying to accomplish with that letter.
Well, it's still hearsay, whether he said it or somebody else said it.
My position on that would be, Your Honor, the question is whether what is asserted in the letter is being offered for the truth of the matter asserted. The language of the letter doesn't really assert anything. What's relevant is Santos' testimony about what that letter means, and the existence of the letter corroborates Santos' relationship with Brainy.
Well, I'll overrule the objection as to the existence. I'm going to sustain the objection to the contents since it doesn't make any sense anyway. Now he can say he sent a letter and what the letter was about, and I'm not going to put that letter in evidence. Right? Anything else?
Not from the defendant.
The only last thing, Your Honor, and I know I've said this before, but Mr. Santos, I know he's come in sometimes and said he's going to do the fifth, and sometimes he's not. I understand there's nothing we can do if he decides to do it mid-testimony, but I would ask the court to do an inquiry outside the presence of the jury as he takes a stand about whether he's going to take the fifth or not, because we've heard jail calls that he's been trying to contact other attorneys, and we have reason to believe that may be an issue. And again, Your Honor's well familiar with him.
Who's going to be your first witness, Mr. Prince?
Mr. Segura.
Your client's going to testify first?
Yes, sir.
Okay. Well, we'll deal with when you get ready to call Mr. Santos. We'll decide what we're going to do. You can remind me you want to hear from him before we bring the jury in. That's probably advisable, so he doesn't take the fifth in front of the jury. All right, we'll take a few minutes.